But in the meantime, we're going to get started so we don't lose any time. My name is Katie Naples Mitchell. I am the legal fellow at the Charles Hamilton Houston Institute for Race and Justice here at Harvard Law School. And I have the distinct honor and pleasure of introducing these two incredible women today who are going to give a rousing talk, I think. So first up, some of you may know Professor Jocelyn Simonson, who is here visiting this semester from Brooklyn Law School. She has incredible scholarship that she's going to talk to us about today about the way that people are kind of pushing back in the criminal punishment system and the role of people in that system through participatory actions, court watching, bail watching, cop watching, bail funds, bailouts, etc. Previously, she clerked on the Second Circuit and also worked as a public defender at the Bronx Defenders for 5 years. Accurate? Great. And then also to my left is Atara Rich-Shea, who is the director of the Massachusetts Bail Fund and also a regional coordinator for the Community Justice Exchange, giving technical assistance to bail funds around the country. She also formerly served as a public defender here in Massachusetts with CPCS, the Committee for Public Counsel Services, which is our statewide public defense agency. And she is one of the coordinators, along with our comrade Mallory Honora of Families for Justice as Healing, and along with me, of CourtWatch MA, which is an originally 5-county project and now more localized to Boston and Essex County, looking at what prosecutors and judges are doing in our criminal courts every day. So without further ado, Jocelyn's going to kick us off with a bit of a lecture, and then these two will be in conversation. I think you're all mic'd up. Great. So we will keep you posted on the food. One other thing I'm going to say before we get started is that if you have not yet signed the ballot initiative to restore the right to vote to people who are incarcerated in Massachusetts, I have signature forms. If you are a registered Massachusetts voter, I really encourage you to sign. I will be here all day if you want to sign. Thank you so much.
Great. Thank you. Big thank you to Katie and David for organizing this and inviting me, and the Houston Institute in general. There are at least 10 free seats over here if people are standing or leaning and don't want to stand or lean, although I too am a stander and leaner, so feel free to sit there. Thank you. Such a pleasure to be here. Shout out to my students who are here. Love you guys. And thank you to the co-sponsors of this event. I guess they're not up there. I'll name them quickly. CRCL, the Criminal Justice Policy Program, NLG, the Prison Divestment Campaign, and the LPE Group. Thank you for co-sponsoring and being here and supporting us. As Katie said, I'm going to talk for a little while about some of the things I think and write about. Maybe 10 minutes or so. But I was invited to come talk about my scholarship, but because I write about what groups and social movements and people who are impacted by the criminal system do on the ground, I thought it would also be appropriate to invite someone who actually does that work every day to join me in conversation, maybe even push back against some of the things I say. That's my hope. So that's the plan. And food is coming. When food comes, we'll stop for a minute and get food and come back. So that's our plan. The title of this talk is Collective Resistance in the Courthouse, and how communities are contesting mass incarceration. And I name these words because a lot of what I'm going to talk about are some of these words, even though I'm going to be talking about sort of collective actions that are kind of messy and happening every day. They're actually interacting in profound and important ways with legal language and with social language in terms of how we construct and defend things like mass incarceration. So when I'm thinking about contestation and resistance and participation, what I'm not talking about is voting, although you sign that petition, or participating on juries, sort of traditional modes of participation. And I'm not talking about protests, which is also a vibrant form of resistance and contestation. I'm talking about ways that groups come together and participate in everyday criminal adjudication in ways that are, on the one hand, kind of basic and mundane, but over time add up to something really powerful and something that can and has led to concrete changes. First though, some of the tactics I'm going to talk about include court watching, participatory defense, and community bail funds and bailouts, not because they're the only examples of these things, but because they're the ones that I've studied and thought about the most. But hopefully we'll hear about some other ones as well. So just to make sure we're all on the same page, talking about contesting mass incarceration, talking about the carceral state. The Prison Policy Initiative puts out this whole pie every year. Pie! And that's okay. So I'm going to leave you to contemplate this whole pie of incarceration while you get yourself some.
I'm not even going to try. I'm going to try to fail. Okay, could you get me one? If someone grab like 10. You like yeah, I told him. Why are you laughing? Listen, Soylent got me last month. Y'all are lucky I'm taking in my Caribbean ass father. He was like, I was like, Dad, my friends are making, Dad, my CI is making fun of you for drinking Soylent. I was like, what's that? And I said, and my dad is like super like gym addict, like physical trainer type, whatever. So he was like, what's that? And I said something like, oh, are you on a diet? You should try going keto. I'm like, no, Dad, I don't eat during the day. And he's like, oh, have you considered meal prep? I'm like, this conversation is over. Me and they come and like try and talk about food. She's like, oh, so your diet? And I'm like, he's like, don't get your hopes up. So I was like, this conversation is over, Andrew. Thank you for participating. Thank you so much.
No, it's not.
I'm gonna email you. I got a call this morning. It's my year, especially like it's not just so funny. But I just submitted even more so than last year. I just submitted it. And there's been a lot of research.
Oh, yeah. No.
Right now, it's I mean, I can't judge Thanks. I try to not look like that every other person that That's what I should do. That's what I should do. Oh no, she's not a lost. And I sent her. She was like, yeah. No, my torts were right. Saved my life. Did y'all do that? It's like 8 torts pre-write that has been circulating for SARS since 2008.
Oh, really good. Yes. It's like probably like small girls.
Yeah. Like he has like a very specific way that he likes things to be laid out. And it's like I know. It's like he gives basically a snap. Someone's sitting right here, but you can go down. Thank you.
Yeah, feel free to get up and everything. Okay, I'm back. So we're talking about how communities and groups are contesting the carceral state and mass incarceration. So just get a little sense of what we're talking about. This is the incarceration part. This is the 2009. This is a snapshot of every given day. So note that there's 2.3 million people locked up in the U.S. on any given day. Hands down, the highest per capita incarceration rate in on the globe. And something else to notice is the orange slice up there, which are people in local jails. And the subset of that up there, which is 462,000 people on any day sitting in jails who have not been convicted of a crime. So that's either because they've been held on bail but they can't afford, probably the majority of them, or because they are detained pre-trial for another reason. The carceral state goes beyond that, though. We can think about correctional control, often called community control. It's going to be important for the way we're thinking about this. And so now, remember our colors, the gray and the brown represent people who are under the control of the carceral state, literally, at any given time. And then we can start to branch out in any number of ways. I'm just going to do it one way to think about families who are impacted by incarceration. So those last two are from the Prison Policy Institute. This is from an organization called Forward. And they have this campaign in which they're highlighting how 1 in 2 people, every second person, in the entire United States, has a family member in jail or prison. And so this graph is rates of family incarceration by race and ethnicity. So to start on the left, and I'll just name these numbers for now, these are the percentage of people living in the United States who have had an immediate family member incarcerated for at least a day. So we can note that for everybody it's well over 40%, but for black people it is 63%. So this is showing us both the impact on families and neighborhoods, entire neighborhoods, workplaces, friends, etc., and also the racial disparities that are going on there. So I could have a whole lecture about what is the carceral state, but I'm going to stop there and move along to thinking about how are the very people who are impacted by this, how are these families and friends and people who are affected every day by the criminal legal system contesting and trying to shift it and say, this is not making us feel safer. One of the ways of doing that is through bail funds. And so on the left is a graphic from the Chicago Community Bond Fund. I want to just mention for a minute before you start reading all those little words, that when I started writing about bail funds only 3 years ago, there were 4 active funds in the country, although there were a lot of people talking about them. Now there are well over 60 that post bail in 60 different jurisdictions. And then there are a number of immigration bond funds that have only started really in the last, I'd say, 12 months in response to the growing incarceration of non-citizens. So bail funds work in different ways. So I have on the right sort of 3 different signs of 3 different mottos. Massachusetts Bail Fund, which is in the House, free them all. Nobody should be incarcerated. Chicago Community Bond Fund, abolish money bail and end pretrial detention. And then the Brooklyn Community Bail Fund, poverty is not a crime. End broken windows, that's a kind of policing. And end money bail. So these 3 signs illustrate how community bail funds, the Massachusetts Bail Fund doesn't have the word community, and I'm going to ask you about that. Why? So that's community bail funds getting together and posting bail, first for one person, and then for a lot of people over time, in a way where what's bail? Bail is supposed to be an amount of money that an individual or their family gives to the court and says, if I don't come back to court, or if I harm someone in the meantime, then the state can keep that money. The court can keep that money. And so the idea of money bail was really to have an individual have money on the line and to release them. But what community bail funds come in is they post bail for strangers who they don't know. And they say, we as a group feel safer if that person's not in jail. And we're going to be on the line if they don't come back to court. Because we don't think money is a good way to ensure that someone comes back to court. And we don't think poverty should be the cause of incarceration. So the bail fund is, in theory, revolving. Bail or bond gets set. People who can't pay the money are incarcerated. So the Chicago Community Bond Fund helps pay bonds that people can't afford. After the bond is paid, the person is released. People have better case outcomes. They're also home with their families. And then at the end of the case, the bond money is returned to the fund. In some jurisdictions, the court keeps a cut of that money. But in theory, a revolving community bail fund can keep going over time. And so what they do is they post bail not just for one person, but for a lot of people over time. Not just to free people, that's of course an important number one thing they're doing, but also to make a larger point about what a subset of the community thinks about some aspect of criminal adjudication and how it interacts with incarceration. I want to talk about court watching for a moment, and I'm going to come back to all of these. CourtWatch MA, also in the house. Court watching can mean a lot of things. All of these can mean a lot of things, right? These groups act in different ways. But raise your hand if you've ever been to state criminal court. Okay, raise your hand if you've been in a non-trial courtroom in state criminal court. So not watching a trial, watching the other stuff. Okay. In courtrooms where trials are not happening in state criminal courts is hands down most of what criminal adjudication means in the United States, or is in the United States. We don't have very many trials. And federal courts exist, and their procedures actually look pretty different, but they're a small subset of criminal prosecution. So court watching groups, which can be made, all of these can be composed of different kinds of people. Sometimes it's the poor people of color most directly affected. Sometimes it's allies or people who are training and spending their time in court watching. Sometimes it's retired people who want to do something with their time. And so these groups get together and they go into these courtrooms in which usually, historically, nobody is really watching what's going on unless it's their loved one who is standing in front of the court. And so they're filling these courtrooms in which judges and DAs and defense attorneys are used to doing things kind of in hushed tones and not in a public way. And they're coming in and they're watching what's happening. And they're changing the nature of the proceedings just by sitting there. They're shifting power. And they're writing down what happens. And they're changing these routine court appearances into something that's public and being watched. And when they do that, they react in different ways. Some groups just sit there and watch. They have matching T-shirts, and they show that they are in support of defendants. Some groups come in to show they're in support of victims. It happens in different ways. And then the most recent trend in court watching, which is what I'm really thinking about, because court watch groups have pre-existed. But again, this kind of court watching, we're going from 2 or 3 to at least a dozen happening now. They are sometimes going to be sitting in that courtroom and holding district attorneys accountable in the moment. So CourtWatch NYC, when they first started up, it was around the same time that the district attorney in Manhattan said that he had a new policy. And that when people were arrested for marijuana or jumping a turnstile, he was not going to request money bail in those cases. And they were sitting in there in the courtroom, and they saw an assistant district attorney ask for money bail, and money bail was set for someone who had allegedly got on the subway without paying. And CourtWatch MA immediately tweeted about it, and the tweet got retweeted and kind of picked up. And within 4 hours, a deputy DA had replied on Twitter and listed out the 6 different reasons that the DA had requested that bail. Defended the decision. But I believe it's the first time in the history of New York City that a DA has ever said out loud a reason for requesting what they think is a small offense as jumping a turnstile. So they're getting out this larger public conversation about what's happening, holding district attorneys accountable. On the right is an example of a community court watching initiative in Chicago. We already know their slogan. Notice it's familiar because it's some of the same groups led by black women and other women of color in Chicago. And they sat in court every single day for this first 6 months after a judge announced that they were going to change the bail policy in Chicago and not set bail, not have people incarcerated simply because they cannot pay. So it's a really profound thing. Might be the first court that ever had a rule like that. They sat there every day and they published a full report. They collected data on it. And they showed that incarceration, pretrial detention for non-payment of bail had decreased somewhat, that racial disparities had stayed the same, and that a lot of people remained incarcerated despite this court order. And then the court changed its rules further in response to it. CourtWatch MA, maybe we can think a little bit about the combination of things that you all do. Where's Katie? But definitely includes Twitter, and also includes some of these other tactics as well. Raise your hand if you're a court watcher. Yeah. All right. Okay, participatory defense is the other thing I want to highlight. Families for Justice is Healing is the one here in the Boston area. This is a snapshot that I just took from the Participatory Defense Network's website. Participatory defense was pioneered in Silicon Valley by an organization called Silicon Valley Debug. Their leader, Raj Jaydev, just got the MacArthur Genius Award this year. So it's certainly a kind of idea that is spreading. And here are some places it is. I don't have the numbers, but dozens and dozens of participatory defense hubs around the nation, and more starting up all the time. And this is an interesting one, because notice who's being held accountable here. It's not just judges or district attorneys, it's public defenders, or it's assigned counsel for people who can't afford to pay bail. And it's saying, we don't just want to have a public defender stand up and represent us. We're going to have a hub of people who work together to try to figure out what's going on in an individual's case. And so that's how it started. The hub is made up of either people who currently have cases going on, or their families, or people who are involved in these things and have stuck around to be supportive and join in a movement. And most of what they do is get involved in individual cases by doing things like creating biography videos for a sentencing or for a plea bargain. But while they're doing it, when Raj talks about this, he has always said, number one, that what they're trying to do is shift the power dynamics within the criminal legal system. So they're shifting power through learning about how things work. They court watch for individual cases. And I think my personal favorite thing that they do is that they really shift knowledge and expertise in individual cases. So raise your hand if you've taken evidence. Okay, so some of you have taken evidence. So in order to be allowed to give an expert opinion in court, you have to be qualified and show that you either have the education or experience or what have you. For very complicated things, you have to share your CV. And you have to be qualified on the record to testify about things. And very routinely, police officers are simultaneously testifying as lay witnesses or in their job, and also then at some point in their testimony being qualified to be an expert. Has anyone seen that happen? It can happen with some frequency. You get qualified as an expert, maybe you know how to recognize drugs, and your expert opinion was that marijuana. Yes, it was, once you've been qualified. So one thing that police officers are often experts on, and in Silicon Valley this happened very, very often, is gangs. So police officers will testify that in their training, they've been trained on how to know who's in a gang. They've had experience in arresting people, investigating cases. They get qualified to say whether a group is a gang or whether someone is in a gang. So what Debug did is they started to get people ready to be qualified as their own experts. So they would have someone in their hub. One time I think it was a 17-year-old, and he said, here's the school I go to. There are gangs in my school. I know what gangs do. They do exist. Based on and then that person got qualified as an expert, and he said, based on my expert opinion, what you're talking about in this case is not a gang. So they're literally shifting what it means to be an expert. So those are 3 examples of things that are happening. And I want to talk about some of these words, some of these language, and then I want to have a conversation. So one of the things that these groups are doing is they're changing the nature of this word community. And the word community, we can notice, yes, it's used a lot in the world. It is really used a lot in the criminal legal system. I don't know a part of it in which it's not used. Community policing, community control, community corrections, things that are done in the name of the community or to protect the community. And so Raj and Pilar Weiss, who's the head of the Criminal Justice Exchange, say explicitly when they talk about these kinds of tactics, as the movement to end incarceration continues to develop and gains momentum, the organizing that fuels it is actively contesting the place of the community. And so what does that mean? Well, let's just look at the Massachusetts bail statute for a minute. These are just excerpts from it. Except in cases where the person is determined to pose a danger to the safety of any other person or the community, bail shall be set in an amount no higher than what would reasonably assure the appearance of the person before the court. So that's an initial thing. In Massachusetts, there's kind of a two-pronged thing. You can detain someone because they're a danger, and there's a determination of whether bail is made. And that siphoning off to the dangerousness hearing is about the safety of the community. Makes sense, right? And then one of the things that judges are required to think about when deciding whether to set money bail and how much money bail to set is the reputation and length of residence in the community. In New York, where I practice, we call this community ties. So if someone's community ties, there's a reason to release them because they're more likely to come back to court. Okay, these things make sense, but notice where the community is here. We're detaining people to protect the community, and then we're sometimes releasing people if they have ties to the community. So now, not yet. Now there's more law. Supreme Court has set up an even more stark binary. So United States v. Salerno, you'll read this when you take adjudication. And this is a bail case in which the court was looking at a federal bail statute, a new bail statute, at a time when bail laws were really shifting toward more bail and more pretrial detention. And they had an Eighth Amendment part of that case, and they said pretrial detention is not punishment, this is regulation. And so then they move on to think about due process. And the court, Rehnquist writes this opinion, says really explicitly, there's a balance we have to make. The court has to reasonably assure the safety of other persons and the community. But on the other side of the scale is the individual's strong interest in liberty. And so notice that this side of the scale is just one person. It's just the person accused of a crime. And the whole community is on the other side. So every time someone is detained, when we're doing a due process analysis, they are on their own, and we, the community, are on the other side. We're being protected. And so now here come community bail funds and bailouts. This is a picture of a Mama's Day bailout in Florida. This is every year in Mother's Day. I think it's been going for 3 years now. Groups, a lot of them are affiliated with the Movement for Black Lives and Law for Black Lives. Individual groups around the country on Mother's Day get together and do a mass bailout of black mamas. And they define black mamas in a pretty generous way. But what they do is they stand there. First of all, they set bail for a lot of people. They go in, they literally bail at as many black mamas as they can, no matter what they've been charged with. And then they stand outside and they greet them. So here's someone being greeted. They put flowers in her hair. They give her support. They ask her what she needs. And so contrast this to the Supreme Court's vision of where the community is. They're saying we're the community. We feel safer when black women are not incarcerated, so they can be part of their families and their communities. And we want to know what does she need, because she's on our side and we feel safer. They're also contesting the idea of safety. Remember where safety sits in Salerno and safety sits in the Massachusetts bail statute. These are posters from the National Night Out for Safety and Liberation, which is held out on the same night as the National Night Out for Crime, which is when police go out and have like community policing initiatives to build trust and safety. Here are some other visions of what safety can mean. And again, the claim of these groups, or me, is not that this is what everyone wants, but that there's no one definition of safety. Some people feel safer without the police, some people feel safer with the police. Some people feel safer with no incarceration, some people feel safer with some incarceration. They're contesting those big ideas. They're also contesting the idea of who the people are. This one hits home for me because I practice in New York, where every day the people of the state of New York stood up, and the district attorney was called the people. So they would say, people, how are you today? And they'd say, I'm good. If they left the room, they'd say, where are the people? And someone would say, the people's in the bathroom. You know, the people were the prosecution. Something like participatory defense really shifts that up and says, well, maybe they're not the people. Maybe they just represent some people. So just to sum up a few things, I think I said this, but these tactics are often, but not always, led by impacted and marginalized groups. Groups who don't have a lot of political power when it comes to voting. People who can't really serve on juries. They shift knowledge and expertise, like I talked about with debug. They connect individual interests to community interests. They shift power dynamics inside the courthouse. And they're met with resistance from state actors. I'd love to hear maybe some examples of that because I haven't talked about it. And so in general, they contest and shift broader ideas about the state's obligation to provide safety and security. Everyone agrees the state has obligated to provide safety and security. That's what a state does. But they're contesting the use of mass incarceration and even the existence of the carceral state as a way to do that. Okay, so now, Atara, stand up and come join me. I'm going to reintroduce you for a minute.
Okay.
Just to remind everyone.
Wait, is this, am
You're
I
good.
amplified?
It's not going to feel really loud.
Okay, great.
Hear you.
I don't want it to be so loud.
Yeah. So you're the executive director of the Massachusetts Bail Fund, and you're also involved because a lot of the times these tactics overlap with court watching, and I don't know if directly, but certainly you're a part of a coalition with participatory defense happening in Massachusetts, and with other tactics I haven't named because there are many, and they're just tactics. So can you start out by tell us about the Massachusetts Bail Fund? I put up a graphic about Chicago, but every bail fund is different.
Yeah.
How does yours work?
So our bail fund is started in 2013, and it's really changed a lot over the past 5 years. Right now, we post bail throughout the state of Massachusetts at jails and courthouses for people who are held for $500 or less. We also combine funds with families and friends for bails that are higher than $500. And that actually reaches a lot of people. We post between 120 and 150 bails a month. We spend about $50,000 to $60,000 a month doing that. But that's not where we started, right? So in 2013, we were posting 1 or 2 bails a month in Suffolk County, and our model looked really different. And Jocelyn talked a little bit about like community and where these things come from and why our bail fund is just called the Massachusetts Bail Fund. It's actually a stupid answer. It's just because we cover the entire state. Massachusetts is actually unique in that we're a bail fund that covers the whole state rather than a particular city or jurisdiction. And I don't think that people who started our bail fund thought about it that way, actually. Our bail fund really started more as like a social work services agency to really address what a need would be and is the person going to come back to court, and then slowly over time, both as we learned ourselves and we thought about it in collaboration with more of our allies and more of our friends across the country, if the reason why a person is held is because they don't have $500 or $400 or $25 and we have that money, why would we keep them there? What is, right? And so slowly over time we became less of a service agency and an explicitly abolitionist, anti-racist bail fund, which is what we are. And so that's how we work now. So right now, actually, we have one full-time employee. His name is Mike. He is at the Cambridge District Court Courthouse, posting a bail for a woman who was held in Framingham for $1,000, and we contributed with Families for Justice Healing with participatory defense to actually free her, which we were able to do today because we have this long history of being able to do this, and because over the past 5 or 6 years, we've created those community ties with organizations that are similarly allied, doing other kinds of work in conjunction with us. So when someone comes to participatory defense now, they know the bail fund is a resource, right? Because our organizations are so connected. And also we've been able to do that in other parts of Massachusetts, right? There's an abolitionist network group out in Western Mass. There are some other organizations throughout Massachusetts who do really deep on the ground work. The Boston Users Union, people who are representing those people who we end up hosting bail for can come to us and say, I know this person is incarcerated, I know this thing is happening, and we have a way to mobilize and respond.
So you refer to this a little, but can you talk about the goals of your bail fund as it exists now that go beyond freeing individual people? You mentioned abolition.
Sure. I mean, Jocelyn and I have talked about this quite a bit, and the idea of what a tactic means versus what is an answer. And a bail fund, participatory defense, court watching, those are not answers to the problem of incarceration, right? I could pay all the bails for all of the people in Massachusetts today, and the jails would be full next week, because the system continues to respond by incarcerating people. That's not real systems change. But what a bail fund does do is it operates a bit as a canary in a coal mine, because we go to jails all the time, right? And we are the people who are going there every week. We know exactly how the jail works over time. Over the past 5 years, we posted at Nashua Street Jail every week for 5 years. We know exactly how that jail works, right? Whereas families with loved ones who are incarcerated there go once or twice, and they don't end up having the same kind of institutional power that we end up having, because we're interacting with this institution all the time, and also, frankly, because we are an organization, right? Like, we made that up, right? I made up my title, but we were able to do that because we just did something over and over again and gained an expertise of it. But if we just did that, all we did all the time for 5 years was just post bail all the time, kind of stay under the radar, never talk about it, just made sure that people were free, we would have done a good thing. A lot of people went free. We posted bail for 2,700 people. That's not nothing, right? That's 2,700 people who got to go home and got to fight their case from a position of freedom. But we would just become a part of the system, right? There's a bail fund in New York City that's funded by the city of New York. Right? And that's the kind of structure we would have entered into, which is we would just be a resource for the carceral state. Oh, you have a problem with bail, just call the bail fund, right? Which sometimes happens. Jails contact us. We have 2 emails from Middlesex Jail today saying we think we have a candidate for you, right? Which is bananas. So we had to open our mouths about what we were seeing so that we could actually support and activate system change. And very explicit about who we post for. We post for anyone that comes across our desk. We don't discriminate based on charge or history. And that is not uncontroversial when you're actually interacting with system stakeholders. And our information and resources are available, and our voice are available for any of the community groups that we talk about and that we work with. I sit on a legislative bail commission, and which is what it is. But most of the people in the room are judges, DAs, legislators, and there's no community there, right? And so, like, the 3 people who are defense friendly in the room are 2 public defenders and me, and I'm the representative of the ACLU in that room, right, which is a travesty, and also par for the course in Massachusetts. But if I wasn't in that room, there would be nobody in that room who'd ever posted a bail.
Also all white.
Yes, it's all white, it is. That's a whole other thing. But, so the goal for our bail fund is to end incarceration, period. Explicitly abolitionist that way. So we don't say end money bail, because what we see, and if you remember that pie that Jocelyn showed, a lot of people are held on bail, but a lot of people are held for other reasons too, pre-trial. And what we've seen over the past 3-4 years as bail has been in the zeitgeist is the system just keeps shifting, right? And so end money bail turns into find other ways to hold people pre-trial. right? So if our messaging is end money bail and it kind of started out that way, that's actually not that hard in a certain kind of way to get to. The harder thing is end pretrial incarceration. And then the even harder thing is end pretrial supervision. And then the even harder thing is end incarceration and supervision, right? And so addressing the entire pie over time. But again, it's not a 1-year fight or a 2-year fight or a 3-year fight. It's like Mariam Kaba says, we're in a 200-year fight. But we're along that.
One of the things that gets my head spinning about the idea of abolishing money bail is that the only reason bail funds are able to participate and have this power is that money bail exists. Because there's, people debate where bail came from, but one of the two leading theories is that it came from Nordic clans in Germany who would vouch for each other and say, we're going to participate in your other state system. And it was a way of counties getting along, it's this method of participation. If you take it away, now who gets to decide who's incarcerated?
We talk about that all the time. Right.
And so in New York State, there was just bail reform, and the bail fund, a number of the bail funds were at the table. I'm thinking of the Brooklyn Community Bail Fund. They sat at the table, and they were in favor of totally ending money bail because they didn't like what it looked like to replace it. They also made the move this year after bail reform. They put out a statement saying, we're not going to post bail anymore because we don't want to become part of the system. Instead, we're going to focus on supporting impacted people, especially Black people, in fighting the system in other ways. So that's a really big move. Can we talk about race a minute, though? You said that's a whole other thing. So let's bring out the whole other thing. We're standing here. We're both people who identify as white women. I'm talking about the work. You're doing the work. Who is doing the work, and what are the racial dynamics?
So we post bail, and if you look at the numbers of people who we post for, it's about 60% Black people, 60% people of color. And it's an incredibly difficult statistic to identify and report on. Katie talks about this all the time. When the courts report racial breakdowns in our courts, they say white and non-white, which is incredibly unhelpful. And not even bordering, it's just racist. And also we're very aware of the fact that I have all the ability in the world to run this organization, right? And the people in my organization who have the ability to post bail because of what it takes come from a certain class and race. Bail has to be posted in Massachusetts in the evening. It can only be posted in cash. You have to have access to a car, and you have to have access to a lot of time. And one of the things that we've noticed in meeting and talking with our family at Participatory Defense and at Families for Justice is Healing is that a lot of people who have experience being incarcerated or with family who are incarcerated don't really want to be re-traumatized by going into jail and waiting for 6 hours for someone to be released. And that's a real part of ensuring that the work we do is led by the most impacted people, is using our bodies and our time at their bidding, at their behest, right? So I have the time and space and mental energy, well, not me, because I don't do this anymore, but the people who are my volunteers have the time and mental energy to go to MCI Framingham and wait for 10 hours for a woman to be released from start to finish at 11:30 at night, and then make sure she gets home somewhere. Right? And we have the institutional ability behind the scenes to make sure that that's funded, and a person who is going to greet this person knows what to do next. But that also sort of feeds into who the community is that is being made safe by these determinations, and who the community is that gets to have a part in it. And it feeds into also CourtWatch, right? Who are our court watchers? One of the things that we realized at the bail fund is that we have about 40 volunteers throughout the state, most of whom are white, most of whom now have this experience of going into jails and realizing, oh, this is what it's actually like, right? I thought a jail was this, and the people who were there were this, but I was completely wrong. How do you broaden that message? When I go into Cambridge District Court and there are people who are being prosecuted there, I live in Cambridge, and so everything that is happening there is happening in my name, right? My white middle class name, right? I am being kept safe by the thing that's happening in court. And a lot of our CourtWatch volunteers, that is the same story for them, right? They're going into court and realizing, I don't live in a community that's policed this kind of way. When someone in my neighborhood is using drugs, or someone in my neighborhood is having a mental health crisis, the following things happen. And I'm going into the BMC and I'm watching all day what happens in other communities when those behaviors are being seen by police. And they're having a bit of an awakening and a huge education on what actually happens in our courts, in our names, which is largely driving offenses, largely mental health cases. Katie pulled the arraignment list for today from the BMC, half of which were crimes of, one of them was,
For tailgating, it was
yeah.
for being too close on the Mass Pike, which is a criminal charge in the state of Massachusetts.
And what was that, drinking in smoking in public.
Boston Public Park, which is an ordinance, a city ordinance.
Yeah, so that's what is actually happening in our courts, and that's been an enormous awakening for people who don't have experience going into court. And
Does
again,
bail get set on those kind of cases?
yes, it does, right? So we posted 5 bails on Friday night in Suffolk, at South Bay, which is where the women now are being held from 5 counties. One of which was a woman who was driving a car that was in her dad's and her name, and the dad thought that the car had been stolen, so called it in. And she was arrested. She had a 10-year-old possession case, so she was held on $500 bail, right? And so that it is absolutely happening, even though we have so-called progressive DAs in Massachusetts who say that it isn't in some places. And the only way to know if it's happening in Massachusetts and a lot of other jurisdictions, not just Mass, is are people in the courtroom watching and reporting on that. Massachusetts courts are not subject to public records laws, so the only way to actually know is to go in and watch.
Great. So I do want to see if people have questions, but because we're in a room of mostly but not all law students, I know you're a lawyer. We haven't even sort of gotten to participatory defense, but what's the role of lawyers in all of these tactics?
So I am a lawyer. I don't practice anymore, but I did for a little while. I think you have to figure out whatever your role is as an attorney, but what's very important to reframe is who are you doing this for, right? So who is leading the work that you're doing, and on whose behalf are you doing it? Please feel free to leave if you have to go. I know that you all are, so I want to just give you the permission. I'm acknowledging that it is happening, and I understand that you have other places to go. And I think public defenders do an amazing work. I was one. And also public defenders have a tendency to feel incredibly isolated on purpose almost, right? So one of the things that participatory defense does is reminds public defenders that they are not actually alone in their defense, right? It's not them against DAs, judges, and police, and like that entire thing. It's not, they are not the only defense for this one person. They actually are a steward of that person and of the community that person represents. And I think that remembering that and knowing that can really shift the kind of isolation that you feel as a public defender. And then research as an attorney and your understanding of the landscape of the law is an incredibly important resource that community people and people who are being prosecuted and communities who are being over-policed need, but not in a patronizing way. I think our tendency is often, as attorneys with all of this information, is often to walk into a space thinking that you know the most, and you know a lot about one thing, but everybody else in the room also knows a lot about many other things. So I think those are just two important touchstones to keep in mind in whatever kind of practice you do.
Great, thank you. So let's see if people have questions. We haven't talked about participatory defense very much. And that perhaps could be a question. But does anyone have a thought or question? If not, we'll tell you about participatory defense. Yeah.
Hi, this might tie in, I'm not sure. My name is Dee, I use they, them pronouns. I was able to do a little bit of court watching with Black and Pink. It just so happened my pen pal had a court case trying to get transferred, she's transgender. And interestingly, the DA or prosecution was doing something really strange where I think they were trying to get her to admit that her Black and Pink pen pals, that Black and Pink was an abolitionist organization. She didn't say that word, but I could see that that's where the questioning was going, and the prosecutor got frustrated. She didn't say. She was like, I don't know, like, they send me letters, they're my friends, like, I'm in community with them. And I know that Black and Pink sees itself as trying to help them have a community established for when they come out, similar to bail funds. And so I'm wondering if you've seen any backlash. I know this is so new and there are so many new lawyers supporting bail fund projects, but is there a risk that we should be ready for seeing prosecutors then say, oh, you were bailed out by an abolitionist organization. Do you actually really respect the law? Do you respect what, accountability and what you're doing this for? Have we seen that yet, or are you worried about that coming up in the future?
I mean, I think that I wished for that. I would welcome that immensely if the DAs and the court started trying to use abolition as a dirty word in the prosecution of people who are from especially vulnerable groups, right? And Black and Pink is another abolitionist organization, and they have a really active Massachusetts chapter. And one of the things that they do along with these other organizations is establish communities for people who are incarcerated, right? And so part of the trauma and torture of incarceration is isolation. And having a district attorney or a judge open that door allows for a stronger defense in how important community actually is to people who are incarcerated in their ability to come out and live better lives, right? So I don't know if this answers your question so much, but most of the resistance that we receive is not so much individualistic, because that just doesn't work. It's the fact that the system is what it is already, right? And so a very easy, small example is how difficult it is to post bail, just how hard it is everywhere you go, or how difficult it is to find out where someone is incarcerated, right? And it's like that not by accident, right? It's like that by design. And it happens over time for many people making very selfish decisions about what's going to make their work easier, right? And not centering the right people and not understanding that what they're doing is encaging humans is torturous. But what we can do collectively, especially with people who want to plug in and can't plug in and aren't already traumatized by this system, is figure out that map and make that public, right? We know how to post bail at every place in Massachusetts, or if we don't, we could figure it out pretty easily. And so that's our role as this resource of being like, oh, we heard the other day, I saw someone getting arrested for having a fight in public, and I know they're held on $250 at South Bay, here is their name. Next week, that person will be out, right? But it's just because we have that kind of network that we're talking about, and because some of us play the inside game of I can walk into court and I have a bar card and I can stand there and I can go into a meeting with the superintendent at South Bay, always holding that line. And some people, it's because they're writing letters to people inside and learning information that way. And for some people, it's because their families are showing up for people in the courtroom. But we're all doing that in the same ecosystem of abolition. So we know that whatever our tactic is, it's moving towards the same horizon.
So something I love about that story, assuming if I'm hearing right that it did not hurt,
Yeah.
okay, that it did not hurt anyone, is that think of how creative that strategy is, right? So so that's the DA using the statute in which a judge has to consider certain factors. Is it Massachusetts?
Mm-hmm.
Certain factors to figure out is a money bail determination?
This was not. But
It wasn't.
no,
Okay.
no.
Well, so what was it a determination?
This
of?
was literally trying to transfer. It was not at all relevant. It was transferring to a women's prison.
So it wasn't as creative as I thought.
Yeah.
But
Never
imagine
is, Jocelyn.
Imagine if you could connect this argument that to not think the carceral state is a good thing means you don't respect the law, and therefore means you're more worthy of incarceration in some
Right.
way. That's really profound. I would also, again, intellectually or socially, rather than if it hurts people, tend to welcome this. I deliberately use that word contestation because I don't think it's a friendly discussion over what we want. I think we're talking about really different ideas of what the state should do, given the fact that we're people who harm each other and live together. So I love that. Yeah.
I want to
Any
hear
other,
that more places.
Yeah.
More questions?
Any other questions or comments? Yeah.
Thank you. Hi, thank you both so much for being here. I
I'm wondering, so you both alluded to this a bit, but I was in St. Louis this summer and I saw some instances where judges would either intimidate court watchers explicitly or like say, oh, I know you can't afford bail, but I'm going to set your bail for $500 and the bail fund is going to pay for it.
Yeah.
So what have you seen instances where like the government tries to co-opt what you're doing, and how do you respond to that?
Yeah. So to go back to, so it absolutely happens. It happens in a lot of places, and that's sort of the greatest fear of a lot of bail funds, but not all, right? So New York City runs a bail fund. They deliberately did that so that they can give money to a nonprofit. It's kind of profound, right? The state says you need a certain amount of money, and then money controlled by the state pays that, just so they can distribute the responsibility. And so the Brooklyn Community Bail Fund recently stopped setting bail because they felt they had become too close to being a justification for sort of these routine processing of people, even if they were being released. So it happens, and bail funds sometimes react. Sometimes bail funds keep going, though, and say, not all bail funds are abolitionists. Some say, well, if we're a part of getting people out of pretrial detention, then that's a service. So I think it depends. What would you say?
Yeah, I think we've seen both, right? So we've definitely seen situations where judges and stakeholders are very friendly to the kind of work that we do, and also situations where, because our court watchers were in the room, people got treated demonstrably better. You know, we've heard that report definitely from public defenders in Suffolk County courts that anytime there's a court watcher in the room, things are just run smoother and are more fair for people. It's a bit like a Trojan horse for me, and I'm actually quite happy about it when judges respond well to the work that we're doing, because in the grand scheme of things, they'll always get surprised at a certain point by who it is I'm willing to post for, right? And so it's never the harder cases or the interpersonal violence cases or the kinds of situations where a judge or a stakeholder or someone whose livelihood is predicated on the idea that paging is fine. At a certain point, we're going to be at odds, right? Like, that's just the nature of this work. It's not friendly. You know, we don't believe anybody belongs in a cage, and if you're a judge or a DA, you do. And that's not, at a certain point, we're going to be at odds. And also, we can work together until we can't work together anymore, right? And also, we aren't going to be quiet about it. And that's the bigger part, and I think the thing that makes people angry is when we start talking about it in public, especially in Massachusetts, when we start sort of like yelling at Sheriff Tompkins for incarcerating women who he knows are victims of interpersonal violence, and he gets angry that there was a public letter about that, where his solution would have been like, why didn't you just give me a call and we could talk about this? That's not the point of the work that we do. So at a certain point, whatever system stakeholder is okay with us bailing this one person out or this second person out is going to realize at a certain point that we're at odds. But let's work together until we can't work together anymore.
I'm wondering if you've seen examples of court watcher similar programs in parts of the criminal system that aren't publicly open to the public. So I'm thinking like juvenile hearings, which are often closed. And then also stuff like competency hearings, which are not technically trials, but are kind of putting people through similar trauma in a lot of cases. And obviously there's like legitimate privacy concerns, but I'm wondering if you've seen like community tactics for accountability in those settings.
So we've talked to a number of juvenile organizations who are interested in this kind of work, and you can't do court watching for that very purpose. I can't go into, we also don't really post bail in the juvenile system partially for that reason. But I know there's court watching afoot for housing in Massachusetts. There's court watching afoot for immigration in Massachusetts. There have been specific court watching by attorneys of particular judges. So it just depends on who has the access, right? Like if a place is closed and only attorneys can be in a place, then they can be doing the court watching. One of the things I really want to talk about with regards to court watch is making sure that it's not a spectator situation, right? Court watching is not a place to watch trauma, like that's not the point of it. Same with bail funds. A bail fund is not a place to feel better about what your money is doing. The purpose of doing these things is to lift up particular issues and to answer particular questions. And there is a time when you sunset court watching, right? I have learned as much as I can about the trauma that happens in the BMC. I don't need to have people every day there, right? And we won't do that again. Because I know, pointed, we're not going to do that again. We've learned, we know what happens there. We know who the judges are that are a problem. We know what is happening. And it only gets you so far. The system doesn't change just because you show it that it's awful, right? It's awful on purpose, right? So you have to have some other reason why you're doing these things. It can't just be for, I see it's awful, right? It has to be something more than that.
I do have an example of that. So in Georgia, it's not a proceeding that is allowed to be non-public. But in Georgia, they have courtrooms inside jails, and those courtrooms, but if it's a trial, they're not in there. And so those courtrooms used to have a sign on them that said only individuals and family members allowed. And so there was a group, the Southern Center for Human Rights was working with them. There was a church group led by a pastor who went and tried to get into the room and were turned away. And so they sued, and they it actually led to changes in Georgia's state rules about open public courtrooms. But if you think about that assumption, it was technically a public courtroom. Also, you have to go through the jail security to be able to get in at all, although a lot of courthouses have security, but jail security is tighter. Think about that these are public proceedings, and it's just how it goes, that the only people there are, of course, going to be defendants and their families. There's just no imagining that a group might come in either to watch and hold people accountable or just to support families and other things. So they shifted the state's rules there. Well, thank you all for coming. Oh, no, we got a question.
You don't want it to end, right?
I was just hoping maybe you could talk a little bit more about abolition and how we get there and what it looks like when we do.
Okay. In 1 minute. Though I am
I'll get you a slide.
by no means, this is the way that I think about it. People think about it in lots of different kinds of ways. But it's building and destroying at the same time. And even though if you wanted, we go burn down National Street Jail right now. I mean, no. And also, people are going to hurt each other, and we are going to have interpersonal violence, and people are going to do things that we need to figure out how to manage and how to deal with that. So you can't we aren't just destroying a system from the inside or attacking a system from the outside, or we are also creating a world in which we want to live where people have what they need to live well. And we didn't really talk about participatory defense, but that for me is really the cornerstone of that part of the work, right? Of people who are currently fighting cases and their families coming together, sharing information, and opening up space for them to think about what their lives would look like and what they want their lives and their communities to look like. And I think of a bail fund as being scaffolding for that rather than an answer for that. Like, we are enabling people to get free, and then participatory defense and the work that Families for Justice as Healing does is a place for people to then go, to have space to figure out what the world would look like if everybody had what they need to live well and how to get there. And that's like and it's important to know your role, right? Like, to know what your lane is and what you're good at. And we're good at this thing, but we work with people who are good at a lot of other things. And what does medicine look like, or drug use look like, and making sure we're working with the Boston Users Union and sex workers about what kind of world makes them feel safe and they want to come back to. So that's in 2 minutes, right? Like, it's a building and it's a destroying at the same time, and it's a very long process.
Yeah, so I do want to, because I'm a professor, I'm going to recommend some reading for you. I write about this stuff. I'm happy to share my work
Should
with you.
read everything
But,
that Jocelyn has written.
there is, I have a quote from it. Pilar and Raj have written a really accessible short blog post on the LPE blog. Shout out to LPE in the room. About these different tactics and connecting it explicitly to abolition. Mariam Kaba has written a number of essays, including about participatory defense. I think it's called Free Them All. If you Google Mariam Kaba, Free Them All. And so there are a lot of places you can go, and if anyone wants to come talk about this stuff some more, I certainly have more reading suggestions. Are there other thoughts or questions? Thank you so much for coming, everybody.